Good morning, everyone. I'm delighted to be involved in honoring John and his eminent contributions as a leading expert in the law of restitution. It's my pleasure to be able to moderate this panel of distinguished scholars, Professor Andrew Kull of Boston University School of Law, Professor Dan Priel of Osgoode Hall, both of whom will be sharing papers that they have written for this symposium, and then Professor Ben Geva, also of Osgoode Hall, who will act as a discussant on this panel, providing commentary after the paper presentations. Now, in his monumental text, The Law of Restitution, which is co-authored by Peter Madoff, John McCamus begins by asserting that restitution is by no means a new idea, nor is the principle that underlies and unifies this body of legal doctrine the prevention of an unjust enrichment. Now, in the pivotal work, Restitution Law, Professor McCamus and his co-author weave Canadian case law together with legal history, decisions from other jurisdictions, and various academic viewpoints to form a coherent basis for taking an expansive view of restitution law in Canada. And the significance of this text, just one example, is illustrated by the comments of Professor Stephen Wadhams, who was on the panel this morning, who refers to the text as an excellent book that will, for the foreseeable future, be an essential work of reference for those interested in any aspect of Canadian private law. Now, Professor McCamus's preeminence as a senior scholar in the law of restitution is recognized both nationally and internationally. And since 1989, his expertise on restitution has been cited by 16 Supreme Court of Canada cases and 32 Ontario Court of Appeal cases. And several notable Supreme Court decisions have relied on Professor McCamus's restitution work in their decisions and in their reasoning. And I refer to Lac Minerals and International Corona Resources, where Justice Wilson refers very specifically to Professor McCamus's paper, The Role of Proprietary Relief in the Modern Law of Restitution. And in 1998, Professor McCamus was also appointed by the American Law Institute to the Advisory Committee for the Restatement of Restitution and Unjust Enrichment, the third edition, which was published in 2011. So that's just by way of background, and we all know this, of course, but I thought I would highlight a few of these key facts. Now, again, it's a pleasure to be moderating this panel. John is a friend, a mentor, an inspiring teacher, and a first-rate scholar. Let me now introduce you to the panel. It's my great pleasure to introduce our first speaker, Professor Andrew Kull of Boston University. Professor Kull is widely recognized to be the leading expert on restitution in the United States. Since 1997, he's been the American Law Institute reporter for the third restatement of restitution and unjust enrichment. He's also been the U.S. regional editor of the Restitution Law Review for the past 19 years. In addition to his senior standing as a restitution scholar, he's also a well-known constitutional historian. His book, The Colorblind Constitution, was published in 1992, won the prestigious Silver Gavel Award from the American Bar Association. For this symposium, Professor Kull will be speaking on his paper entitled A Consideration Which Happens to Fail, in which he addresses the role of the consideration concept in restitution law. I'm now pleased to turn over the floor to Professor Kull.
Good morning, everybody. I'm very pleased to have the opportunity to join in what I think we all feel is first and foremost a tribute to John McCamus. My connection with him and our joint connection with the law of restitution has been referred to obliquely by several people. I would just like to emphasize that everyone is aware of the very wide-ranging nature of John's activities and good works. Most of us are more particularly aware of one aspect than another. I am aware of one that I wonder if you can really appreciate the scope of it, which is John McCamus's service to the cause of law reform in the United States. And law reform in what might seem a particularly thankless area, that of the law of restitution, which I don't know how many people were at the dinner last night. I realized it was sort of the punchline of many of the stories that people wanted to tell. You couldn't make those jokes about restitution in the United States because people wouldn't know what you were talking about. I mean, at all. So this was sheer altruism. And there are, for the work of this kind, tireless work in the service of a project of the American Law Institute, there are no glittering prizes at all. John was there for the satisfaction of helping. I was a beneficiary, we all were, and it was a very significant contribution. My topic begins with the question, why are English and American law professors using the words failure of consideration to mean such different things these days? I wonder if that question is even intelligible. In the United States, it would not be. American lawyers do not use the expression failure of consideration at all, and it is so long since we have used those words that people do not remember what they used to mean. This is really not an exaggeration. I scarcely know what they used to mean. I'm an American lawyer. I do know quite a lot about the law of restitution, and it came to be sort of more forcefully brought to my attention just last year. I think I was rather late in coming to this recognition, that among certain English scholars of restitution, and not just English ones, the expression failure of consideration is currently being used to describe a vast area, I mean, one of the principal divisions of the entire law of unjust enrichment. And as I say, from the American point of view, this comes as a distinct surprise. Our restatement of restitution and unjust enrichment, which is 2 generous volumes, does not include the words failure of consideration at all. What are we missing, is the question. My experience as an American lawyer is that very often, if we don't understand something that the English are doing or saying, the best answer is very often to ask a Canadian. The Canadians understand, they have an easier time explaining to us what the English are doing than we can usually find out for ourselves. I did try to ask a Canadian. I sent an email to John McCamus. I said, what is going on here with failure of consideration as a division of restitution generally? And John said something like, I have never actually found that that was an interesting concept. So that left me sort of on my own to my own devices in trying to approach this question. I have gone ahead and done that, and without the benefit of Canadian advice, I should say. If I had it, I expect my remarks would be more substantive, and not having had it, they will probably be more breezy, but I'm going to do the best I can. Now, first, the difficulty of the terminology. Failure of consideration seems to mean, well, there's sort of 4, I want to put people in 4 camps. There's what the term used to mean back when everybody used it to mean the same thing. There is the American version of that, where we still, I think, talk about the same thing. We just don't call it failure of consideration anymore. There is the new expansive idea that failure of consideration actually describes a huge swath of the law of unjust enrichment under that name. Then there are the people that I would call the fellow travelers who accept the category, accept the rationale, but do not want to call it failure of consideration because they think that term is discredited, which it really should be, and so they call these other things. They call it failure of condition, failure of basis. They call it conditional transfer of wealth. In all of these situations, what this category is what the American lawyers would typically call restitution in a contractual context. It turns out we are talking about the set of cases in which people make a contract and for one reason or another it does not work out, it is disrupted, ineffective, fails. What are the restitutionary consequences? Well, a little more definition of what I mean. When people all used the word to mean the same thing, the words, what did they mean? They were talking about the basic proposition that starts with, I pay you money in advance, you promise to do something in exchange, you don't do it, I can get my money back. That's failure of consideration in the traditional way. If you want a discussion of this problem, you find it in Maddon McCamus' Law of Restitution, McCamus' Law of Contract, Wadham's Law of Contract, books like that. That is the traditional idea. It leads to a traditional set of problems. The English judges at some point said, upon a total failure of consideration, and from this they got the idea that the failure had to be total, or else you couldn't have this claim. So this, of course, leads to difficulties, arbitrary results, either saying there is no consideration because you got a little, there is no restitution because you got a little bit of the promised performance, or if that's too difficult, pretending that there was a total failure when obviously there wasn't, this kind of thing. This is one of the reasons it's discredited. That's the traditional thing. In the United States, we have this remedy, we have this idea, we have not called it failure of consideration for a long time. We would say, this is a remedy for breach of contract that's called rescission. Rescission and restitution is a typical way to call it. Under certain circumstances, if you have given a valuable performance, you are met with a material breach, we would say. As an alternative to damages, you might say, thank you, Your Honor, I would rather get back what I gave him. And the availability does not turn on proving or pretending that it was total or otherwise. It, in theory, and I think mostly in practice, turns on how effectively can we unwind this transaction. If it's one where we can restore both parties to the status quo ante, sometimes it's very easy to do that, then it's a great candidate for rescission and restitution. If it's not possible, if we have non-restorable, non-returnable values having been exchanged, it's not a good candidate. So far, so good. No great departure from tradition. The expanded view of failure of consideration, I'm certainly oversimplifying, and I may not be doing justice to various subtleties, but I think what it is this. I think it comes straight from the famous book by Peter Burks. He is describing, I'm paraphrasing and taking all sorts of liberties, the essence of unjust enrichment as being essentially unintentional transfers, unintentional to some extent, transfers that are imperfectly voluntary, let's say. And first category, the ones that he wants to call vitiated consent, mistake, fraud, duress, things like that, fine. Then next category, well, not vitiated, but qualified consent. And this is the idea that turns out to be so expansive because the proposition, again, with apologies, is that in a contractual setting, if I perform first, it's on the understanding, the assumption, the expectation, you could so easily say, the condition, the basis, you could say, that I'm going to get your return performance in exchange. And if for some reason I don't, then there has been a failure of the at least implicit condition on which I performed for you. Now, if you stop for a second, you'll see this immediately occupies the entire field of everything that could possibly go wrong in a contract that doesn't run perfectly. It includes, notably, every instance of breach of contract. You might want to say, oh, we'll only talk about the important ones, but frankly, logically, every instance of breach of contract is thereby revealed to have shown, in retrospect, that the performance by the person who went first was not fully voluntary, and by our basic principles, this means potentially yields a claim in restitution to the value of what was given. It also means every instance of a restitutionary claim where the performing party does not have a claim to enforce the contract because the contract is unenforceable for any reason, illegal, void or voidable for mistake or frustration type reasons. We consider them to be exactly the same. Even other situations, the plaintiff in breach or defaulting plaintiff situation, these English writers describe as the example of failure of consideration. Yes, I may have breached my contract, but I didn't intend to make you a gift of my performance. It occupies the entire field. So you have the English writers who say this is the principle of failure of consideration. That includes now there's a restatement of the English law of restitution. It includes that. It includes notably Andrew Burroughs' treatise. The point is not the names, but it's a significant segment of the opinion. Then there are the people who I call the fellow travelers, who adopt the category, they adopt the rationale, they say, well, we certainly don't want to call it failure of consideration. That is so counterintuitive. Peter Burke said, well, this terminology is unfortunate. It's simply a cross that the common law has to bear. Other people come and say, no, we can put down that cross. Let's call it something else. They call it failure of basis. The new Goff and Jones on restitution calls it failure of basis. They call it failure of condition. The Canadian fellow travelers are the ones who call it conditional transfer of assets, something like that. I mean, these are our friends Smith, Chambers, et al. Even talking about this distinction of approach, it would be a mere quibbling and pointless, I suppose, if I didn't think that beneath the surface were some very significantly different attitudes towards solving the problems of what happens when we have disrupted contractual exchanges. Withdrawing from a contract, actual or supposed, is how John Dawson talked about this. I want to suggest very generally, I think there are basically different attitudes, and they differ in the extent to which these two approaches want to look to the contract to find the answers to the problems of redressing enrichments that arise from the failure of the contract to run as anticipated. And that consistently, the Americans are much more willing, I mean, we do it instinctively, to look to the contract, actual or supposed, to find our answers there, and the English resist doing that. And the question is, what does that suggest? It's not US versus UK, but in attitudes towards a contract that hasn't worked out properly. Now, the first very big difference, it's maybe the most important one, the most controversial, and I think for that reason I can say the least, is the whole question of restitution as a remedy for breach of contract. I think you can see it's implicit. If the whole idea is your breach of contract means that my whole performance has been on the basis of a condition that didn't realize itself, and I have an unjust enrichment claim, any instance of restitution for breach is a remedy, as people say, completely off the contract. It's an alternative. I have my remedies on the contract. I have, in every case, an alternative remedy off if I can show unjust enrichment. The American point of view is the polar opposite. I'm not going to try to defend it. I would just say the American would start with the idea that all of my remedies for breach of contract, whether they are damages, specific performance, some form of getting something back, are contract remedies. Everybody knows that there's some chance you're not going to do exactly what you said. Everybody also knows that there's a set of remedies in case you breach, and everyone knows that they're not perfect. None of this comes as a surprise. It is why people are interested in security devices, and it is ultimately taken into account in the contract price. I will not pay you as much for your promise as I would if I had 100% certainty that you would perform or that I would get a perfect equivalent That's what, at any rate, leave that aside. The other thing I want to say is that again and again, let's say it's not a breach. Let's say it's part of the part of the subject where there is no enforceable contract. I have performed, I went first, right, to some extent, I've performed, I do not have a contract claim against you. Why? Well, because it's unenforceable, because it's illegal, because we've decided it's been avoided because of mistake or frustration. Any of those reasons. I'm in breach myself. I would say repeatedly, so it's common ground that if there's any remedy, at least I would say, it's common ground, the remedy is not on the contract, it cannot be by definition, therefore it's in unjust enrichment, fine. How do we decide that? Again, I would say we look to the contract, characteristically, and I had 3 or 4 examples of nice cases that I think everybody has heard of, at least remembers, and I don't have time to go through 3 or 4. Let me mention 1 or 2. A very famous case that everybody, I suspect, has heard of at some point, Fibrosa SPA versus Lawson-Coombe Barber, the famous frustration case about the flax hackling machines that were supposed to be sent from wherever it was, up in the Midlands, to Poland. They made the contract on some day like July 12th of 1939. Not surprisingly, it required delivery in Gdynia, which is Gdansk, Danzig, at the expense of the seller, and it required a down payment. They were supposed to get £1,600 in advance. They got 1,000. This was custom-made flax hackling machines that the seller was agreeing to supply. And as I say, the contract was made in July. It was 6 weeks later that Germany invaded Poland. 3 months earlier, Hitler had demanded the return of what they called the Polish corridor. The point being, a contract made under those circumstances, could it not be reasonably concluded that the parties, against the background of the war news and against the background of what was thought to be the absolute established English rule of contract law, that in cases of frustration, as they used to say, the loss lies where it falls, wouldn't it be reasonable to think, actually the parties have here allocated the risk of loss from force majeure at least to the extent of the first £1,600, or at least to the extent of the 1,000 that they actually got before they started making the machinery, and that we have a contractual solution to what is otherwise seen as a restitution problem. Now, it turns out that it's interesting, the lawyers for the seller tried to make that argument, apparently, in the House of Lords, and it went nowhere. I would have said, in the United States, that would have concluded the matter. Let's see, other examples. I'll give just one, because I'm told that I've run out of time. Here's another one of my favorite examples. I promise I'll be short about this. I wonder if the case of the Reading pipe is known at all in Canada. It is one of the best American contracts cases, bar none. It is where the man made a contract for building his beautiful house on Long Island, and of course elaborate specifications. One of them said, all of the pipe in the following applications is to be genuine wrought iron pipe, lap welded, of Reading manufacture, it says. And then it turned out, after the entire house was built, that some part, quite a lot, of the pipe had actually been made with genuine lap welded wrought iron pipe that had been made not in Reading but in a place called Cohoes. And expert testimony is to the effect that if it were not for the name of the manufacturer marked on the outside, this pipe was indistinguishable. Even in a metallurgical laboratory, you could not tell the difference. Now, this was discovered before the final installment of the price had been paid. And so, at least in theory, it was actually a plaintiff in breach case. The builder had not performed in accordance with the specifications. There was a condition. He was supposed to get an architect's certificate before he could get the balance of his payment. The owner was refusing to pay. And so on its face, an unjust enrichment claim, it would certainly be called failure of consideration by the English restatement. The question is, can we tolerate this apparent impossibility of getting the last money? Benjamin Cardozo, I mean, one of his great opinions, says, I mean, I would paraphrase by saying, in order to know what to do here, we have to decide what it was the parties actually intended. If they really wanted to contract for a forfeiture, so that if you don't have perfect performance, you are not entitled to the last installment of the price, there's no objection to that in New York contract law. Fine, if that's really what they want. Did they really intend that? And then he explains why he's skeptical. He talks about the harshness of the result, such an extreme forfeiture for a trivial, almost unnoticeable deviation. And he says, line I particularly like, from the conclusion that promises may not be treated as dependent to the extent of their uttermost minutiae without a sacrifice of justice, the progress is a short one to the conclusion that they may not be so treated without a perversion of intention. Cardozo-esque way of putting it, backwards, but I think the thought is clear and is another nice example of the way we would try to find the answers to these issues by being readier, more ready, I think, than the English approach to attribute implicit intentions and understandings to the parties with regard even to circumstances that they have not explicitly anticipated. Now, I had interesting suggestions about what would explain this difference and so forth. I would, however, be even more interested to hear the Canadian explanation of the phenomenon that I'm talking about, so I will stop there. Thank you.
Thank you, Professor Kull, for that fascinating account on different perspectives on the failure of consideration. Next, we have Professor Dan Priel. He is a relatively recent addition to Osgoode's full-time faculty. He's received numerous accolades for his research and his academic achievements. Before joining Osgoode in 2011, Professor Priel was an assistant professor at the University of Warwick in the UK and was also the Oscar Rubinhausen Fellow in Law at Yale Law School. He received his doctorate from Oxford and served as a law clerk to the Israeli Supreme Court. Let me turn it over now to Professor Priel to speak to his paper, Justice and Unjust Enrichment.
Thank you very much, and thank you, John, for giving me the opportunity to speak here. Because if I remember, my first time that I spoke to an Osgoode audience was a talk on unjust enrichment or the law of restitution, and I think we can say that John and I had some disagreement on the topic. But it's the kind of disagreement that I suspect would have been the one that led Henry Kissinger, or perhaps it wasn't Henry Kissinger, to suggest that the reason why academic disputes are so intense is because the stakes are so low. And so to some extent, I want today to talk about an aspect of the law of unjust enrichment and to suggest that perhaps a dispute about what it is all about may not be that low. And it may actually be, I need to make this introduction because the law of unjust enrichment, as Professor Kull has said, and those who have been yesterday at the dinner would also remember hearing there, is still an area of law that many people look at with some suspicion. Does it really exist? So just to give an example, yesterday a senior partner from a leading law firm here in Toronto said, the law of restitution, what is it really? And the suggestion was that this area of law is something that we're still struggling to understand what it is all about. And interestingly enough, unlike other areas of law, this is true, I think, not just of outsiders to the academic world, but even among academics, there is some question as to the relationship between unjust enrichment and justice. And okay, just to give a sense of what we're talking about, so I start with 2 quotes from 2 articles from the late 1970s by John McCamus. As a general rule, it is perceived to be unjust that one party should gain a windfall benefit at another's expense unless a gift was intended, or it is also perceived to be unjust simply to profit at another's expense. And that all seems quite reasonable. And in fact, I think many people would say, well, obviously the law of unjust enrichment has to be unjust. All law needs to be unjust, right? Here's, I defer here to the great John Rawls. Even those who have not made it past the first page of A Theory of Justice, when you read there, justice is the first virtue of social institutions. But we don't really need John Rawls to know that. If you just went to someone on the street and you asked them what the law should be, and I suppose they would say the law should be just, and it's wrong for the law to be unjust, and moreover, it's important that the law correct injustices. So, but obviously, if that is all that we mean by unjust in the law of unjust enrichment, that would not be very interesting or helpful. So the next question that we're therefore trying to understand is, or to answer, is what is it really that we mean when we talk about unjust in the context of the law of unjust enrichment? And so I'm going to give you a brief survey of various views that have been found in the literature. So, why is it that it worked before? It isn't. This wasn't supposed to happen. There we go. So, here's one view by Peter Berks, who's already been mentioned here. For the most part, he says, unjust enrichment merely gathers up the law's reasons, not being contracts or wrongs, why an enrichment should be given, or if you want a more succinct statement, but for the need to retain a trace of normativity, one might just as well speak of pink enrichment. So the word unjust in the context of unjust enrichment doesn't really mean much. It really is just a word that we use to gather various causes of action that really don't have that much in common. And moreover, he warned us or told us that when trying to understand the law of unjust enrichment, we should not look up to an abstract notion of justice, but we should look down to the cases and the statutes. So that's, if you want, one extreme view. At the other end, you have another Oxford professor, this time someone called Arthur Goodhart from 1953, and in a little-known book called English Law and the Moral Law, he has this sentence: the branch of the law which was formerly called quasi-contract has recently tended to change its name to unjust enrichment. Its new name is useful because it emphasizes the moral origin of the various rules comprised under this heading. So we have these two, this contrast between the one view that says, really, the word unjust is a little bit dangerous. We should actually be careful of it because it suggests that lawyers should look to abstract justice, and that's something that lawyers should not do, and Peter Berks is quite clear of that. And the other side, which says, no, actually, the law of unjust enrichment is there to get us to deal with moral questions or to solve moral questions by appeal to morality, and we should definitely look at our sense of justice. But let's try to break this down a little bit more. Okay. So here, so one sense of what we talk about when we talk about the justice or injustice in the context of unjust enrichment, I think, is something like property. And I'll give you first a little brief, I don't know what to call it, it's not even a poem, coming from Charles Bowen, who perhaps would not have deserved this being mentioned here had he not been an actual judge. And his little poem, "The rain it raineth on the just, and also on the unjust fella, but chiefly on the just, because the unjust hath the just's umbrella." And so here we have a sense that the justice is related to something to do with property. If you take someone else's property, you're being unjust. And if we look at what typically is kind of in the first class of unjust enrichment, you're told is the kind of indisputable, unquestionable example of an unjust enrichment case. Peter Burks calls this the core case of unjust enrichment. It's the case of a mistaken payment. The bank, by mistake, puts money in your bank account. Or to give an example of something that actually happened to me, you quit working at a certain workplace, and by mistake, they keep paying you a salary even after you've left. In this context, what is it that, why is it that I think many people would say you ought to give that money back? The answer is, well, it's not really yours. And we don't care about, I think, most people at least, would say that whatever legal title here says, it may well be that as far as the legal title goes, I have title to the money. It's not really mine. And the reason why one should give it up is something like a notion of property, and it harks back to ideas about what is one's own, and therefore what one is entitled to possess. Another sense of unjust enrichment that you find, I think, also in the literature is this idea of unjust enrichment as fairness. And here the quotes that I started with from John are, I think, an example of that. And I found perhaps an even simpler or easier example to grasp this idea coming from Antonin Scalia in a famous lecture that he gave in 1809. Parents know that children will accept quite readily all sorts of arbitrary substantive dispositions. No televisions in the afternoon, or no television in the evening, or even no television at all. But try to let one brother or sister watch television when the others do not, and you will feel the fury of a fundamental sense of justice unleashed. And I think there is a sense of an obvious sense that when we talk about unjust enrichment, we talk about injustice in this sense of fairness. If we have two people who are similarly situated, it's unfair, it's unjust to treat one of them one way and to treat someone else differently, regardless of the question of what the standard is. It's just, whatever the standard is, it should be equal to or similar to people who are in a similar situation. And I think if we go to kind of one of the leading cases in Canada of unjust enrichment or restitution, Petkus and Becker, I think something of that is exemplified in that case. So that case, I don't know if you know it, it involves an unmarried couple that had a business that they developed together for many years. Things went bad, and when they separated, the male the male partner who had the property was under his name said it's all mine, therefore he was not willing to give anything of, or to acknowledge the contribution of his wife, his life partner, Becker. They went to court, they went all the way to the Supreme Court, and the Supreme Court said both members of this household made roughly equal contributions to the creation of this business, and therefore it's, even though they didn't use the word, I think it's clear that what they meant, it's unfair that one of them will end up with all the money that came from this business, whereas the other will be left with virtually nothing. So that's, I think, another sense of injustice that is underlying the question of, or is found in the literature of unjust enrichment. Then we can take an even further step, one that wants to engage justice in an even more direct sense. I have a long quote here from John Dawson, but I'll just read you a simple or shorter one that's coming from a judgment of the Supreme Court of Israel. Here's a chance for me to actually use my background and my knowledge of the Hebrew language. So one justice in a decision called Ashir and Pfirrman, unjust enrichment law is a kind of super law available whenever a person should have a cause of action and a remedy, and no other law provides it for him. So that's a rather extreme view compared to, if you compare this to what Peter Burks has said. Here, the law of unjust enrichment simply allows the court, at least according to this statement, to get around laws that otherwise get you to an unjust result. Briefly, what happened in that case, it was a case in which one company copied the products of another company for various reasons which we don't need really to address. Neither IP law nor tort law in the tort of passing off provided a remedy, and yet a majority of the Supreme Court of Israel said we use the law of unjust enrichment to give remedy to the plaintiff. So far we have at least 4 different understandings of what is it that justice means in the context of unjust enrichment. Either it's the legally unjust, the Peter Berg's view, or it's justice as some sense of property, or some sense of fairness, or perhaps even at a more extreme sense, or justice as equity. But is that all that there is? Well, Canada has made in recently, some scholars from Canada have been at the forefront of developing a new idea, perhaps not a new one, but a new understanding in the context of unjust enrichment as corrective justice. When we talk about justice in the context of unjust enrichment, it is corrective justice that we have in mind. Again, I have some quotes. I should just say that Mitchell McInnes's confidence that there is, on the core, there is general consensus judicially and academically that unjust enrichment operates on a model of corrective justice. The confidence with which he has stated this is equal to the confidence with which he asserted that the Supreme Court of Canada has abandoned the unjust factors model of unjust enrichment. And I think John McCamus has quite convincingly has shown in a recent article that that is not the case. And I think that Mitchell McInnes is also mistaken here. As we've seen, it's simply not the case that there is consensus or anything close to this in the context of what injustice means injustice means in the context of unjust enrichment. Now, at first, it may seem that actually he has at least the support of the Supreme Court of Canada. Restitution is a tool of corrective justice. When transfer of value between 2 parties is normatively defective, restitution functions to correct that transfer by restoring parties to their pre-transfer positions. And that seems, the word corrective justice appear here, and that sounds plausible. But in fact, if you look at this statement is so vague, it actually says whenever there's been a legal cause of action, a legally identified cause of action, the law calls for some kind of response. So that does not help us understand really or distinguish unjust enrichment from, I would say, any other area in which from tort law or contract law where there is a successful claim. I'm not going to read you all of this. So Ernest Winery has come to the aid of the Supreme Court, and in a law, that's from a recent book just recently published. The point of Winery, I think, is to, Winery has a tendency to write in a manner that I find a little bit obscure, but I think if you kind of boil down this long quote, it ends up something that sounds like the property view of unjust enrichment. The point of liability is to assure that transfer and retransfer of value is in accordance with the party's freedom of will. Hence, the law construes as normatively defective a transfer of value in which the transfer did not intend to give something for nothing. So if we have some property that was physically passed to someone else without the intent of passing it, then we have this mismatch between physical possession and legal possession. That calls for some kind of response, and I think that can be explained in the sense of injustice as property that I talked about before. Now you may say, well, so what? So what are the stakes here? Some people call it corrective justice. Some people call it justice as property. Does this really make a difference? Well, let me try and suggest in my conclusion that actually what may be at stake here is an understanding of the place of unjust enrichment and perhaps of private law more generally within the whole range of the rest of the law. And if you want a different way of putting this, to what extent private law really is private. And so those who favor the corrective justice view are going to be those who find either corrective justice is the only form of justice, and I put here a quote from Hayek as an example of someone who seems to think that the rules of what he calls a private law society are the rules that are necessary for the creation of spontaneous order. And so those who really believe that corrective justice is really the only form of justice out there will be sympathetic to the corrective justice view. But even those who are not, they will try to limit unjust enrichment to corrective justice if they want a limited role for courts in changing the law. And so now you see that actually the debate between the corrective justice people and those, let's say, the example from the Israeli Supreme Court is one that actually has to do with the role of courts. And that's not a private law question. It's really a public law question. It's a question of the institutional competence of courts. It's a question about how much we want courts to be involved in changing and correcting the law. And so those who don't want the courts to have a very significant role in correcting the law, in changing the law, they will favor the corrective justice view. It's not because it reflects the nature of unjust enrichment. It's not because it captures something that's inherent in the cases. Rather, it's a view about the institutional place of courts in the legal system. And I will, I think, stop now.
Thank you, Danny, for sharing your insights. Now I'd like to introduce Professor Ben Geva, who's a professor of law at Osgoode, a well-established expert in commercial, financial, and banking law. He is going to provide a commentary on the presentations.
Okay, it is of course my honor and privilege to take part in a symposium in honor of John McCamus. I know that for you, most of you are rookies. We think that we are kind of the same old-timers, but there was a time that he was senior and I was junior, and I actually met John 36 years ago in the dinner that I was taken for my recruitment visit to Osgoode Law School. And since then, I have always seen him as a beacon and reason and common sense and source of inspiration in areas of common interest. And of course, the question is, what is the common interest? What am I doing here? Well, I always took the position that commercial law is more a applied contract, torts, and property laws, and therefore there have been a lot of common denominator. And I should only add that if I hardly taught these basic courses, it's attributed maybe to my skill in avoiding teach them, or in the how to say it, in the failure of deans to discern that that's what commercial law is all about. But anyway, whatever I know about it, again, I'm not an expert, but I will still have something to say in connection with particularly the failure of consideration. In the written paper also, Danny identifies it as something of unjust enrichment. And what I want to do now is more kind of trying to see why is this all, I wouldn't say mess, but why there is all this kind of, where this failure of consideration haunts us as something separate from breach of contract, which I tend to agree that that would be the simpler way to deal with it. And I think that the answer is pretty much in English legal history. And I want to take you back to the Middle Ages. Before there was law of contract and or the ways that we understand it, and I think that the source to this doctrine is there. The point was that in medieval common law, of course, you could not enforce promises just because they are supported by consideration, but rather seller of goods or lenders of money to and for the contract was sued on what was called debt on a contract. But debt on a contract had nothing, well, I wouldn't say had nothing, but was not based on the promise to repay the loan, but rather the point was that the borrower or the buyer or defendant in general was liable not because he had promised to pay, but because he or she had received a benefit, which in turn cast upon him or her a duty to pay. And that is, so the basis was this benefit, and which has been, the phrase was quid pro quo. This is where we are all using it, but this is where it came from, was used to indicate the necessary correspondence between the benefit and the duty. However, the transaction was binding not by the force of the agreement, the consensual agreement, but only by the delivery of the thing or by the payment of the price. And so I think that you already see where I'm heading, and indeed, as early as 1094, then there is a judgment by Chief Justice, it was then Mettingham, that said that if a seller failed to convey land according to his covenant, the buyer might choose whether to demand the money in a writ of debt, or to demand the covenant to perform, or a writ of covenant to perform the covenant. So basically, that was failure of consideration par excellence. The seller failed to transfer the land. The buyer is entitled to the money back. And this is where actually we do have the formula of money had and received to the plaintiff's use. Again, well, this actually was developed more in the 14th century. And it also was that if A gave money to B to give it to C, and if B failed to do that, then A may sue B in debt. Again, no promise, no agreement, but just the mere fact that I gave the money to you to give it to somebody else, and you didn't do it, entitles me to get the money back because it was basically, it was not yours the way that Danny kind of described it. However, still, medieval law had a very important limitation. The sum was supposed to be fixed. So on one hand, the writ of debt applied also to payment of penalties, to payment of things where there was custom as to the value, but you couldn't use it for what we called later quantum merit. Because again, the idea was that there has to be, for some reason, there has to be the magic of the fixed amount was necessary. So it's not so much the agreement, but rather the delivery of the benefit and the fixed amount. And again, in the 15th century, the judge said, if I bring cloth to a tailor to have a cloak made, if the price not determined beforehand, then I shall pay for my mistake. He shall not have an action, he shall not have an action of debt against me. So that's how kind of was as late in the 15th century. In the 17th century, things changed in a sense that quantum merit became to be recognized, but still, so this kind of broke some barriers, but still the big difference was when there was this indebitatus assumpsit swallowed the writ of debt and kind of, so to speak, integrated into the writ of, to the action of assumpsit. But indebitatus assumpsit was the way that assumpsit swallowed debt. If I may use a gruesome analogy, I understand that crocodile, unlike tiger rip off his victims, but crocodiles swallowed them as they are, and well, what happens next is just to your guess, but the idea is that it swallows them as they are. So even though it all kind of was integrated into assumpsit, basically it was the writ of debt that was there that has become indebitatus assumpsit, but now with quantum merit allowing for action without the fixed price, so to speak, that was actually only small step for allowing actions in what we later on called quasi-contract on ill-gotten benefits. And there were several categories for it. One of them was, again, the failure of consideration. So here was pretty much the kind of paradox. On one hand, the action in contract in general has been a subset which has been based on action for damages for breach of contract. But it was action for damages. But on the other hand, this, for the benefits, for the debitatus subsets was for the benefit, and therefore, failure of consideration somehow survived as a dinosaur as a separate heading, rather than being simply taken over by a subset as breach of contract. Well, you're supposed to do something I didn't do. Maybe I have excuses, maybe I don't have excuses. So we do have the breach of contract. And it was Lord Mansfield in Moses Macfarlane that put it in whole kind of succinct way. The gist of this kind of action is that the defendant, upon the circumstance of the case, is obliged by ties of natural justice and equity to refund the money. By the way, very few people, of course, realize that Moses versus McCarran was a bills of exchange case, but that's off the point. What I want to say is that actually the point is in English law, and I can give some other example, but of course in the 2 minutes I don't have, and that was not also my plan, that sometimes people come with this broad principle, justice or I don't know what of that, but then, well, wait a minute, what about precedent? So then there is this expansion, and then there is contraction of falling back into recognized headings that were already used, that it's always safe to go inside them. And Canadian law, by the way, in some place like, well, I wouldn't give the examples, but in some cases actually broke away from the tradition. But primarily that has been typical to English law. And that's why we, as I say, it's kind of safer to remain with this kind of rubrics, or dinosaurs, if you want to say. And then from time to time you have this kind of excursions into trying to go back to these broad principles that was the way it was ably demonstrated by Danny, in a sense of trying to look, well, what this is all about, rather than what were the kind of precedents, the ways that they were at that point. And again, I mean, fibrosa, I think, is a classic case that should have been decided as a matter of contract. And because at the end of the day, that's it. The question is what was contemplated by the parties. And so why even go to this failure of consideration, which only bring to these goals of the past? And my concluding sentence would be, I will cite Maitland, a great English law historian, say the forms of action we have buried, but they still rule us from their graves.
Thank you, Professor Geva, and thank you to both panelists, Professor Kull and Professor Priel, for contributing to this wonderful discussion. We do have an opportunity for questions, comments, objections, and while you're thinking those through, Professor Geva has an objection.
No, just to take my watch.
All right. So at this point, I'd like to call upon two of Professor McCamus's students, Christopher Loss and Ariel Bloom, to make a brief presentation.
Thank you very much. It's a great honor to be here, Professor. Now that the panels relating to the two subjects that you taught so well for so many years are over, it's time for two of your students to embarrass you a little bit. First of all, again, thanks for giving us some time here. Arya and I are both alumni of Professor McCamus's contracts and restitution classes, and we wanted to come up here and express our appreciation to his dedication to teaching over the years. And Professor, when we heard about the symposium, we thought it would be more than fitting to give you a gift to express the immense gratitude that all of your students feel for your work as an educator here. And we were trying to think of what to get you, and everyone who's taken contracts and restitution with Professor McCamus is familiar with the case of Attorney General and Blake. This is a case involving a British spy who went double agent, sold all the state secrets to the Soviets. The Brits ended up capturing him, bringing him back, and locking him up. The spy was, of course, George Blake. Blake busted out of prison in Britain and fled back across the Iron Curtain. and wrote a book about his career as a double agent. And the British government didn't take too kindly to Mr. Blake making money from book sales, telling about how he broke his oath of allegiance to the crown. So they sued to disgorge the profits from the book, and they won. So we've got a very special copy of this book for you, Professor. It's been signed by all of your students here. It's been signed on behalf of all your students, past, present, and future. Aria, if you do the honors.
Absolutely. Professor, please come up and join us as we'd like to award a token of the appreciation of all the students here who you've enriched with a legacy of both how to behave as a professional, as a person, and legal insights which we will take into our careers for the rest of our lives. Thank you, Professor, and please come up.
Wonderful. Well, I'm delighted to conclude with a final thank you to Professor McCamus for his exceptional contributions to the field of restitution law as a scholar and as a teacher. The value of his research and his texts and his role as an expositor of restitution is a tremendous gift to the public, to the law, to lawyers, to students, to academics, and everyone for years to come. So thank you again, and thank you to all the panelists. Let me pass it now to Jamie for some lunch instructions.
Yes. Thank you very much. I'm very aware that I'm the only thing that stands between you and lunch, but you are my captive, so I just want to say a couple of things. For me, it's been a really exciting morning, and I don't think we've said it before, but the idea of the symposium is to honor John by creating new scholarship. And so, excuse me, I'm still choked up from the presentation. I'm so proud of the students and so glad that they've honored you, John, in this way. But just the idea of the symposium is to create new scholarship and to honor John in that way. And we haven't said it yet, but the papers from the symposium will be published in a special issue of the Osgoode Hall Law Journal. And, you know, that's a very, very important part of this project. And we haven't mentioned this either, but John has a relationship with the Osgoode Hall Law Journal. He's a former editor-in-chief, and so it's particularly appropriate that the celebration will go forward in the form of a special issue of the Osgoode Hall Law Journal, which is, you know, which speaks both to the scholarship but also to the teaching aspect as well, because those of us who have been editors-in-chief of the Law Journal know that it's a very important pedagogical exercise that brings those of us who serve as editor-in-chief into very close relationship with the students who work so hard on the Law Journal. So I did want to say that. I'm also, I've just been very excited by the papers and presentations this morning. I want to thank all the speakers. Very much looking forward to the written papers that will emerge, and we focused on John's sort of hardcore academic areas this morning, and we'll turn in the afternoon to law reform, civil liberties, and access to justice. It's going to be an exciting afternoon. Before breaking for lunch, I also want to take a moment to say a few thanks and to acknowledge our sponsors. So we see that the sponsors, whoops, we've still got the PowerPoint on, but you've seen this, that with the screenshot that John's publishers of the contracts book and the restitution book are sponsors of the symposium. So Irwin Law is the publisher of the contracts text, and without hesitation agreed to help us sponsor the symposium today. Likewise, Thomson Reuters, publisher of the Law of Restitution, We're only too happy to help us with the symposium and to be sponsors as well. But in addition, not showing on the screen, we have other sponsors. And I want to mention that the Harry Arthur's Collaborative Grant Fund is a sponsor of this symposium, as well as Iman Montgomery and our colleague Paul Emond, in addition to, of course, Osgoode Hall Law School and York University. So those are our sponsors. She's not here, so we'll probably do this again this afternoon, but Stephanie and I would especially like to thank Jody Ann Rowe Butler, who is the research coordinator administrator for the law school. She has knocked herself out with all the arrangements for today, and we're very, very grateful for her professionalism and her attention to detail in helping to make this happen so smoothly. In addition to Jody Ann, we'd like to thank the IT department for handling the technical details. And finally, I always like to remember to give thanks to James Cheng, who is a former student of John and myself as well, for doing the artwork and preparing the posters, both for the symposium today and for the dinner last night. So we're on to lunch, and the one thing I'm going to say about lunch is that we are under a little bit of a timeline on lunch, because we'll be joined by the president of the university, Mamdouh Shukri, who wants to make some remarks in John's honor, and those will begin at 12:30 sharp, and then we'll proceed from there with the keynote address by Roderick MacDonald. So lunch is available. We have made arrangements for those attending the symposium to take their lunches to the breakout room, so that you have a table to sit at. And so I'd invite you to take your lunch and plan on being back at 12:30, and we'll round you up and make sure that we get started again right at 12:30. Thank you so much for the morning sessions, and we look forward to the afternoon.
I wish I could-